So welcome, Professor Donald Clarke. Donald Clarke is Professor of Law Emeritus at George Washington University Law School in Washington, D.C. His academic specialty is modern Chinese law, and he has written on a wide range of subjects, including criminal law, corporate law, legal institutions, and the legal issues presented by China's economic reforms. Professor Clarke founded and maintains China Law, the leading internet listserv on Chinese law, and writes the China Collection blog and the Chinese Law Notes Substack newsletter. He has also served as an expert witness on Chinese law matters in a number of legal cases and has advised organizations such as the Asian Development Bank, the U.S. Securities and Exchange Commission, the U.S. Public Company Accounting and Oversight Board, and the U.S. Department of Justice. It's an honor to be talking to you today, Professor Clarke. Thank you for being here.
My pleasure.
Could you please share a little bit about your background and your current research focus?
So I was born and raised in Toronto, and then went to the U.S. for college, where I started studying Chinese, which included a summer at Middlebury where I took classical Chinese, and that was really enjoyable and interesting. Then after college, I had the chance to go to China for 2 years. So that was my first experience in the country. That was in the late 90s, late 70s, just after Mao died, 77 to 79. After that, I did some graduate studies and went to law school, then went to teaching. And I, with the exception of a few years of practice, 3 years of practice in the mid 90s, basically it's been all China all the time as an academic. And even, in fact, my practice experience was largely about China. So, really, ever since, I guess I started studying Chinese in 1973 and started being an academic around 1985. And that's, kind of everything I've done. I haven't been terribly diverse in my academic side. I guess it's all been China. Within the Chinese law field, I've done lots of different things. I started, I guess my early interest might have been in issues of criminal law and human rights. I did some writing in that area, but I think mostly, if you were to put a kind of general subject definition to it, it would be for a long time kind of legal issues surrounding China's economic reforms. How does the legal system respond to China, not being a largely planned economy anymore? How do you, make the legal system fit the demands or the needs of the market? So, I've written on real estate law and Chinese local government debt. More recently, then, I've been looking more at systemic issues. How should we think about, the Chinese legal system as a whole? How do the legal institutions fit into the political system?
And when you say the Chinese legal system, what are you referring to?
Okay, well, that's a great question. And this is something I struggle with, actually, because one of the propositions that I'm trying to advance in my work is the idea that, legal system isn't necessarily the best way to describe what people who study the Chinese legal system are actually looking at. So in other words, what do we mean when we say legal? And is that, an appropriate adjective? Is it the best one to describe the set of institutions that are usually, grouped together under the term legal system? So, for example, one of the questions is, of course, is it a system? I mean, is it one system? And a well-known and much respected scholar of Chinese law, Stanley Loveman, who just passed away recently, I said somewhere or other that, he didn't think there was a Chinese legal system. There were Chinese legal systems, plural. And then, he made his argument to that effect. The thing that I would like to question, I guess, is it's a bit of an insurmountable problem, because if we start out by calling it a legal system before we've even researched it, we've kind of already settled the question that really should be open to discussion. On the other hand, if we don't have a preconceived kind of notion of what we should be looking at, then how do we decide, what to look at? So, we're not studying Chinese cuisine. Well, why aren't we studying Chinese cooking? It's because it doesn't, as someone who works in a law school, it doesn't kind of fit my idea or anyone else's idea of the kind of thing that a person who works in a law school and writes in legal journals should be studying. But by the same token, we do need to be careful not to assume that legal is the best word. One sort of consequence of the word choice is in the very institutions you study. So, for example, if we use the words the Chinese legal system, people are going to think, okay, courts. They're going to think, legislature, but they probably wouldn't think police. If we think about like the U.S. legal system, nobody and very few people would think the U.S. legal system includes police, even though police obviously do, have a very important role to play in society. And they certainly do things that intersect with the legal system, quite a bit. Every time an arrested person turns up in court, obviously the police had something to do with that. Right. But, people in law schools who study the legal system don't study the internal workings of the police department. On the other hand, if we were to use a different term to describe a bunch of institutions in China that are of interest to us, then we might include the police. So, for example, that's why I like to use the word, order maintenance system. And, some people might use different words, but when I look at the institutions in China that are conventionally called legal institutions, I want to include the police because I think they are the kind of institution that you should study together with, the courts and the legislature and, the system of lawyers and people like that. I think the police fit in kind of organically with that. And so that's why I would use a different term. Then it makes you more open, to thinking about, well, what other institutions should we study if we think about order maintenance instead of legal system?
Let's take a step back, and I'd like to ask about the previous approaches to studies of the Chinese legal system. You mentioned that just discussing the Chinese legal system already assumes certain understandings of what is a legal system. Can you tell me a little bit more about this idea of an order maintenance system and why you would rather take a step back and examine the wider order systems in China rather than moving forward with the legal Chinese legal system?
It's really a question of, the framework that you use, and you can call it, a paradigm, right? Generates a set of questions. And those questions then, generate a set of answers. So we could always ask, any number of questions, and we would get answers. The challenge lies in finding the questions that are important and significant. So here's another approach to looking at China would be what I call, the rule of law approach. And if you have what I call, the rule of law approach, that generates a set of questions that you're going to ask. For example, you might say, how independent are the judges in China? Because that's an important question about judges. If you have this kind of rule of law approach, could we think, under the rule of law, right? This idea, we think, well, having an independent judiciary is pretty important. You might also ask, how much legal education do the judges have? That's pretty important. Did they go to law school? Do they have experience as litigators? Something like that, right? So those are the questions you would ask. And you can certainly answer those questions in China, right? I mean, we can go look and see, like how independent are the judges? It's a bit hard to get a data-driven answer to that, but nevertheless, we can discuss that, and we can talk about how much legal education the judges have. But the question is that important? We could ask, how much legal education do the members of the Kansas City Chiefs have? We could ask that question, and we could answer that question, but would it really help us to understand much about the Kansas City Chiefs? Right? No. So that's why I think selecting the paradigm, your framework, is really important to make sure that you're asking questions, the answers to which matter. Let me give you another example. This was a really interesting experience I had in China many, many years ago when I was just a young law professor, and I was teaching first-year property. I had done so for many years, and I was interested in kind of the Chinese property system. So I was in China talking with some fellow academics, and they were wondering about the U.S. property system. Now, as you may know, because you've taken first-year property, right? We have a system of recording where if you have an interest in property, you go and you make a filing somewhere that declares publicly that you have an interest, in this property. And the whole point of that is that there's a public declaration somewhere. So I had already taught property law for several years at this time, I think. And then my Chinese interlocutors were saying, well, where is this? Where are the records kept? Like which office has control? And I didn't know, like, is it at the county courthouse? Is it at the county executives? Is it done by city? Is there a centralized state thing? And the point is, in U.S. law, it doesn't matter. That's not an important question. The whole point is, as long as everybody knows where the record is, then you go and look there when you're doing your title search. But it's not important to know where. But, from the Chinese standpoint, they thought it was important because they're thinking, which office has control over property, right? Because that's like really important. Which government department sort of controls the movement of property, because they thought that the recording was all about like government control. So, if I had known more about property, I could have given them an answer, but the answer would have been completely misleading to them because they would have thought they had discovered something important about the U.S. legal system and about, property rights in the U.S. Actually, they wouldn't have discovered anything important, right? I mean, it doesn't matter whether it's in the county courthouse or in the county chief executive's office. That's completely, that's an unimportant fact about the U.S. property system, right? I think that what I call the rule of law approach, we can get answers to the questions. They're not always important. They might be important, and they might not be. It all depends on, kind of the circumstances. So let's take another example. Several years back, one of the presidents of China's Supreme People's Court, you look at his CV, he has zero legal education. Not a single year, not a month. He didn't even have a online course or something, correspondence school.
Shocking here in the US.
So the question is, what should our reaction be? Should we say, wow, this guy's totally unfit to be president of the Supreme People's Court? Or, right, and that's what we would think if we're using the rule of law approach. We think, wow, that's what this fact tells us. It's a fact. And we conclude China put a completely unfit person in charge of the Supreme People's Court. But, if we're willing to move away from that, then we can say, wait a minute, what does this tell us about what the job of president of the Supreme People's Court is about? The fact that it does not require legal education. It does require, as this guy had, a very considerable background in the kind of order maintenance system. In other, he'd been a provincial police chief at one point, I think. So that, that tells us something about the job. So instead of just saying, wow, this is like really weird, we should step back and think, well, maybe our question, maybe we're asking the wrong question. If it yields an answer that makes it look like China's doing everything wrong, we should say, well, what if they're not doing it wrong? What if that's right within that particular, system?
It's very interesting that you say we should maybe take a step back from the rule of law approach, because that's been a dominant paradigm through which to study a lot of different countries, and it's enabled a lot of comparison across countries, measuring have they met rule of law, is it rule of law, rule by law. But you're putting forward this approach that's taking a step back and not necessarily putting things on a comparative level, but asking what is there in the first place. And you did that in one of your recent papers on Anti-Anti-Orientalism. Can you tell me a little bit more about that Anti-Anti-Orientalism approach and how that supports this shift towards thinking about China as an order maintenance system rather than a legal system?
Let me sort of run through a bit of history of the concept. So we have anti-anti-Orientalism, which comes from anti-Orientalism, which comes from Orientalism, right? So we have, Orientalism, the book, the book and the concept made famous by, Edward Said. And the idea, of Orientalism and why it's kind of a bad thing. I mean, Orientalism is always used in a critical sense. No one says proudly, I'm an Orientalist. You accuse other people of being an Orientalist and you don't mean it as a compliment. Right. So what is Orientalism, when it's used kind of as an insult? It means, an analysis of, a foreign society that's, overly focused on the differences and, makes everything out to be exotic. And usually it finds the differences to be ridiculous at best and bad, at worst. So, oh my God, the Chinese use white in funerals. Everybody knows you're supposed to use black in funerals. How ridiculous, right? Or, writing from like right to left. What's that all about? And, so that's kind of the problem, right? With Orientalism is that it kind of blows up differences and makes up differences where maybe they aren't there. That of course leads to misunderstanding. So then we get, the reaction, which is anti-Orientalism, and which says, well, things aren't actually that different. And, if they are different, that doesn't necessarily mean they're bad. Okay. But at least what I observed, I believe I observed, let's say in the case of Chinese law studies, was a tendency to, because of sort of a creditable desire to not just be, condemning China for everything, it led to what I think was just a denial of difference, rather than separating those two questions. One is, are there real differences? And second, how do we evaluate them? Which should be two distinct questions. It would tend to conflate them. And starting out from a conclusion that, we don't want to be condemning China all the time, then working backwards from the conclusion to say, well, actually, the differences aren't that great. And so my purpose in, writing that article, Anti-Orientalism, was to say, well, let's not assume from the beginning that things can't be different in a very fundamental way, because there really are, quite large differences in human societies. And it would, if you think about it, it would be kind of weird if, Chinese culture came up with, something called a legal system that was really, very similar to, what, people in, Western Europe and then North America ended up with. Just on its face, of course, it's possible that could have happened for sure, but it doesn't seem to me to make a lot of sense. It's kind of a default assumption that. So that's what I was trying to do with that article, to kind of defend the notion that, at least in principle, we could find some things that are very different about China. And then after defending that in principle, to say, and here are some examples where I think things really are, very different.
It has been a very interesting premise, and I know it's unlocked a lot of more recent scholarship looking at China and taking a step back to, as you were mentioning, with thinking about China having an order maintenance system. Scholars have now been looking at finding new ways of understanding what China actually has, rather than just imposing this idea of what a system, a legal system, looks like. And one thing that scholars and you yourself have also been looking at is how policy and law interact in China. How do you understand the relationship between law and policy in China?
Here's what I would say. I think the boundary is somewhat fuzzy, and but there's an institutional reason for that, and the institutional reason for that is that in a one-party system, it doesn't matter very much. So if you were to say in the United States, what's the difference between law and policy? You would say, well, law, federally, you'd say, well, law is what Congress passed, and policy is, the discretionary space that the executive has, to do stuff within the bounds of whatever Congress has authorized or the Constitution, has authorized it to do. But we can easily say is something law or not. We can look and see, did Congress, pass a law saying that made it law? And the reason that's important is because not everything the executive wants becomes a law, right? It has to go through this particular process. If it can't make it through that process, it's not law, and that makes a difference. So, now we move over to China. And, we have the National People's Congress, National People's Congress Standing Committee, both of which are empowered to make laws of, national effect.
Mm-hmm.
Then we have the Communist Party. We have Xi Jinping at the top, the Standing Committee of the Politburo, the Central Committee, the whole Communist Party membership, and then the whole country. If the Communist Party leadership wants something to be enacted into law, they could get it. It's not like the National People's Congress is going to push back. This is not, people do talk about the National People's Congress as, some people say, well, no longer a rubber stamp for something. But, really, the only kind of maybe, I don't even want to use the word independence, but maybe I have to use that word. The sort of separate status of the National People's Congress comes from the stature of whoever's leading the National People's Congress. So, we could say, okay, maybe it's a power base for some particular leader, but it's not like the individual members are kind of a separate, political force. It pretty much they pretty much have to do, what they're told. So I think it's not an exaggeration to say that, with perhaps very few exceptions, what the leadership wants, the party leadership wants, it can get. And we can take as an example, Xi Jinping pushing through, for example, the constitutional amendment in 2018 to allow to get rid of the term limit for the position of state chairman, that they wanted to go on for a third term. Given that, so if you're a party leader, and you're faced with some urgent problem, let's say, you believe it's an urgent problem that needs a governmental response, why would you care about whether it had been enacted into law or not? Because it's just a question of time. And if the problem needs solving now, it would seem silly to wait and get it enacted into law, given that it's definitely going to happen. So the policy doesn't gain more legitimacy by being enacted into law. The leading political body in China is not the National People's Congress; it's the Communist Party of China. So you might think, and you might realistically think, what is the point? And so I think people within the Chinese system, would correctly feel that there's not a big distinction between policy and law, precisely for this political reason, which is that, any policy the party wants could ultimately be made law without, too much difficulty. And so, why spend a lot of time worrying about the distinction?
There are a lot of similarities between what we in the US see as a legal system and what there is in China. We can look and see that there are judges, there's a National People's Congress, there's court systems where people go and bring their claims. And so it is really easy to just assume that it all works exactly in the same way. But what you're saying about law and policy, it sounds like are almost the same thing with how the CCP is governing China, is a really interesting idea where I almost wonder, is there even a useful distinction between saying Chinese law or Chinese policy? And how does that tie into your idea of using the term order maintenance system rather than legal system?
Okay, so good question about what courts are doing, for example, and the difference between law and policy. So one of the the features of Chinese courts is that they are officially, not just unofficially, but officially supposed to take into account not only law, but also policy, and also things like concerns about social stability. I mean, that's always the term that's used, social stability, in their decisions. So again, that's why I want to be careful about using terms like legal to describe what they're doing, because most people, if they hear the word legal, to them that has something to do with a system of rules, right? And so we do have sets of rules in the Chinese system, passed by the National People's Congress and the National People's Congress Standing Committee, various local governments. We have those sets of rules, but those are not the only things that courts are supposed to take into account. Now, one could say, well, lots of courts around the world, they take into account other things besides rules, but they're not supposed to. And I think there's a difference between a system where you're not supposed to do it and a system, and you have to do it under the table and illegitimately, you got a bribe or something, or, you like the look of the defendant, or, whatever, that you're not supposed to be doing. I think there's a difference, an important difference, between a system where you're not supposed to be doing that and a system where you are encouraged to do that and criticized if you don't do it. And, you could lose your job, or you get, points off your, a black mark on your record if you haven't properly taken into account the things you were supposed to take into account. So, for example, order maintenance. What it means concretely when you're a judge, among other things, is don't make a decision that is going to result in a bunch of people storming the local government office and overturning police cars because they're angry. Yesterday, the day before, there was a story in the Wall Street Journal about domestic violence in China and how difficult it was for women to get a divorce, even when, they could show a lot of domestic violence. Now, what's the reason for that? The reason for that, I mean, there's many reasons for that, but one reason for that is this social stability imperative, which is that if you have one party to the divorce, and it's 99% of the time it's going to be the husband, that threatens violence if the divorce is granted. In other words, the husband says, if you give a divorce, I'm going to murder my wife, murder you, and then kill myself. Right? You being the judge, or makes a threat like that. And if they carry out that threat, who's going to get punished for it? The judge is going to get a phone call, from the party secretary or something. What's going on down there? It's your fault that you made this happen. So that's, social instability is someone committing an act of violence like that. So what happens is that basically, in many divorce cases, who wins? It's the party that can most credibly threaten to commit violence. I mean, if the wife says, I'll commit suicide if I don't get the divorce, and the husband does not make an equivalent threat, oh, maybe the wife would win. But again, it's not a question of what does the law say? It's a question of who's going to create an incident that the judge is going to get blamed for. So it can be very difficult for judges. I mean, I feel for these people because, the law may point one way, but, they have very, very strong incentives pointing the other way to basically minimize discontent. And this is reflected also in kind of the official score sheet for judges. Now, for many years, they had something called the case quality assessment system for judges, which was phased out, I think, in about 2016. But it has basically been restored, at least in some ways. And what does that mean? It means they score judges on various, various aspects of their performance. Now, what are when we look at the things that result in a negative score, there are things like, how many times were your judgments appealed? Now, if your judgment is appealed, it doesn't mean you made a mistake, right? It just means that one of the parties was dissatisfied. How many times did your judgments result in petitions? People, going up to Beijing, and demonstrating or something. Again, that doesn't mean you made a wrong decision. It just means that somebody was dissatisfied. So what does this tell you? This tells you, right, that the concern of the authorities is less with whether the judge's decision is right or wrong, as with, does it create discontent? Right. So that's shown very clearly on the actual specific score sheets that judges have. It's shown in the fact that courts have what they call stability maintenance funds, which is a special fund they can use basically to buy off discontented people. You give one person the victory in the lawsuit, but then you give the loser some amount of money. Say, well, we'll help you out anyways. You didn't have a legal right to what you wanted, but we'll give you some money to kind of help you out. I mean, and it's called the stability maintenance fund. So we see, all across the system, these institutions and practices that say very clearly that the institutions we think of as legal institutions are doing more and something different from simply deciding disputes according to law. Nobody can do that perfectly, right? But that's not even the ambition. The ambition is something else, which is basically kind of minimize total social discontent is the term I like to use, Somebody's got to win and somebody's got to lose. But if you can kind of figure out what decision is going to create the least total discontent across society, then that's probably what you should do.
This does sound very different from the judicial system that we learn about in law school and the kind of expectations we have for our judges here in the US system or even in the European system. I know that there is some consideration of policy when judges are thinking about issues here in the US legal system, but not nearly to quite the same extent, and especially not to the extent where there's a fund to be able to ensure that the discontent is tampered down. It certainly sounds like what we term judges that are in China kind of take more of the adjudication role than the U.S. judge role. And I know that you have talked a lot about the language and the translation of these different terms in your work, and talking about how we can't necessarily translate the word judge as like Baguan.
Yeah.
It's not a one-on-one translation. Can you talk a little bit more about how the language that we're using to discuss the Chinese legal system impacts our understanding and our expectations when we go in to study Chinese law?
So it's a bit of an insoluble dilemma because, ideally, in talking about, well, first of all, it's an insoluble dilemma because why do I look at these people at all, right? Why do I look at these people who have the name which is translated as judge? Why do I look at these institutions that have a name translated as court, unless I've already decided that those are the sorts of things that a law professor should be looking at, right? Again, I'm not looking at what we call religious institutions. I could be. I'm not even looking at Communist Party rules, right? So there's a bit of a kind of a presumption already driving things. So, but it's an insoluble problem. And then the question, so once we get there, what do we call these people? What do we call these institutions? As long as we're using an English word, we're already starting down the road towards being misleading, because before we've even started, we've already created in kind of the reader's mind this expectation that is basically, that it's more right than it is wrong to use that word. Because if I didn't think that, I wouldn't have used that word. In other words, I call these, if you call these people judges, then you're telling the reader, yeah, these are at least mostly like judges in your mind, reader. So that's always a problem. Now, if I just use the Chinese word, ideally I would just use the Chinese word, right? And then the reader would look at that and they would say, I don't know what this means. And then they would read on to find out, well, what exactly does it mean, right? What does this person do? And then they could decide for themselves. Is this kind of more like a judge than it's not like a judge? Or should I use some different word? And the reader would decide for themselves without the prejudice that has already been inserted in their mind by using the word judge. The problem with that is then you end up basically writing the article in Chinese. So, if every single noun, I'm going to, instead of saying judge, I'm going to say fa guan. Instead of saying court, I'm going to say fa yuan. In fact, in one article I wrote, I started doing that. But then I just did a global search and replace at the end because it just got too ridiculous and unreadable to try to do that. So it's really hard to do. I mean, ideally you would do that, but in other words, use kind of native terms instead of the English translation, and then let people work it out for themselves. But it's in practice, that's really difficult to do. So I just try to insert footnotes telling people don't take this too serious. I mean, you can do it sometimes. So I like to use the word adjudicator instead of judge, because like adjudicator, it's a lower status thing, right? Judge, you think, oh, that's a real high status job. Adjudicator, what does that mean? You can be an adjudicator in the social, security system, adjudicating claims. And so I think actually adjudicator is a bit of a better word. It's more neutral and it doesn't have that connotation of high status because, people who are Faguan judges, in China do not have this high status, at least that federal judges have in the United States. So this issue of what words to use is really a difficult one. You run the danger of sort of implanting in the reader's mind sort of a picture of what this person is that's very hard. Once you've done it, you can't get rid of it, no matter how many footnotes you have to say, well, this is not actually, what you're thinking, because you use that word, you didn't use another word.
Yeah, this is one of the wider philosophical questions that plague comparative studies, international studies, translation, all of it. And so I don't want to get too far into the weeds with it. But I do notice that throughout this conversation, even having defined and discussed that the Chinese legal system is very different from what you expect when you're talking about U.S. legal system, and that term doesn't fit. I'm still using the term Chinese legal system.
Right.
You're still using the term Chinese legal system. It's just the operative word. And so maybe it's a question for another time. But what can we do to address all of the gaps in the definition and the assumptions? And I think that's what you're largely doing, and that's been a massive push that you've made within Chinese legal studies, is saying take a step back, define these terms. Maybe don't use such a term that produces these ideas in your reader's mind. Maybe don't say Chinese legal system, think of a different system. And I've been seeing that in the literature of people starting to define what the term law means in their article and things like that. I'd like to instead turn to talking about, as we finish up this interview, talking about what you think people with a background in the US law should know about the Chinese legal system and what would be important for them to know when they hear the term Chinese legal system. This is different from the US legal system.
I guess it depends which people. Now, one of the things that, and what their job is, why they need to know, right? So one of the things that actually, inspired me to write is probably about 3 articles that all basically, kind of say the same thing, but in a different way, right? Over time, was my experience as an expert witness on Chinese legal matters in U.S. litigation. Right. And I found that kind of the default, it's interesting, China thinks that, the whole U.S. government hates it, but, actually the judiciary, is remarkably, has kind of rose-colored glasses, it seems, when they look at China. In other words, they basically start with the default assumption, most, not all, but it seems many courts start with kind of the default assumption that the Chinese legal system, is like Canada's or something. It's a foreign legal system, but, we can understand it pretty well. And that if you want to say it's not, that's a very hard row to hoe, Basically, whatever the doctrine might say, the burden of proof is on the party that is arguing that China is not, like Canada.
Right.
So I think it's, very hard for, people who haven't, looked closely at the Chinese legal system and, taken a course on it. It takes me 39 hours just to teach a survey course, in Chinese law. You can't expect, judges to devote that kind of time to it. But I think maybe the main source of, misunderstanding is just not getting how thoroughly embedded within the political system, the Chinese legal system is. So, for example, I think maybe courts would have a better picture of the Chinese legal system if they pictured judges as kind of maybe adjudicators of claims within the Social Security Administration. So in other words, relatively low-level officials, who are part of the executive, they don't have independence. They're not supposed to have independence. It would be silly to think of them as, people who ought to have independence. I think that would give them a better picture. I mean, it doesn't mean that the judges are, dishonest or corrupt or anything like that, but they're just kind of low status people in many cases. And they have things on their mind other than strict application of rules. So I think that would be, I see federal courts or, state courts sometimes talking about like our sister courts, in China. And, that sort of demonstrates that they think that, these courts are basically like them. Unfortunately, I think that's a misconception.
And what do you think is important for people with a background in U.S. law to know about the Chinese legal system?
Okay, so, as I mentioned, it would be good for, for judges to know something about it, but it's a big ask. But also, just if you're a scholar, I think it's always good to know something about a foreign legal system in order to understand your own legal system better. Because, when you look at aspects of the foreign legal system, it makes you question aspects about your own system you didn't question before. At least it makes me do that. So let me give you an example. We look at the high conviction rate in China. It's literally over 99.9%. And people look at that and say, wow, that's like really high, that's terrible, right? That's really high. But, then if you start to think critically about like, well, what are we comparing it to? Are we comparing it to people who actually go to trial on criminal cases in the US, because like that's not very many people that have the actual trial with a lawyer that like you see on TV dramas, right? The vast majority of cases are plea bargain. Plea bargain's guilty. It's a guilty plea. So if we were to take, the percentage, as the denominator would be like everybody ever arrested, and then the numerator would be everybody ever convicted, including all the plea bargain things, that would probably be pretty high also. And that's not something I thought much about. I'm not a U.S. law specialist. I didn't think much about that before looking, at Chinese law. And then also, when we look at Chinese law, as I mentioned before, we see judges very often, not following the law. Must have been, I think just earlier this year, maybe it was last year, a professor at Harvard Law School, Holger Spaman, came out with, and some colleagues came out with a very interesting paper in which it was an experiment in a controlled setting, but, they have judges come for, workshops on this and that. And they took a bunch of the judges and they gave them sort of questions about cases, and how they would resolve them. And they supplied what the law was, and in many cases, the judges just paid no attention to what the actual law was, and decided in some different way. That's like a really interesting result if you're saying, well, China is very different from the U.S. because like Chinese judges don't care about the law. And then you find, wow, these are like judges that went to Harvard Law School for a workshop and they had this case study in front of them. And, the law, it was designed for the law not to be ambiguous on this issue. It wasn't like what counts as reasonable. It was some very non-ambiguous question. So that's like, it makes you think twice about, your own system and maybe some things really aren't so different.
Yeah.
So I've got to like take it all back. I've got to write Anti-Orientalism now.
Yeah, there are a lot of similarities as well as a lot of differences, as we've been discussing. It's been really eye-opening. In regard to U.S.-China relations, moving a little bit away from the legal, what critical points of misunderstanding cause friction in the U.S.-China relationship?
China is always complaining, that, oh, you don't understand us and all that kind of stuff, right? I don't think that's the major problem, in U.S.-China. I mean, there is misunderstanding, but I don't think it's the major problem. China is pointing missiles at Taiwan and threatening to take it over. That's not a misunderstanding. Chinese policies in Xinjiang are not misunderstood. They're very well understood. And they create friction. That's just how it is. I would say a misunderstanding that used to be common, I'm not sure how common it is anymore, is that, China was, like very centralized, and Xi Jinping says jump and everybody across the country jumps, and it's certainly well understood in the China studies community. I'm not sure how well it is understood outside, but I think the message is getting out that, there are a lot of gaps, between what the center wants and what happens down in the provinces. So that, I think, is maybe the major kind of remaining misunderstanding. I don't think that, I don't put a lot of stock in China's claiming to be misunderstood. And if you only understood us, then, you'd be friendlier or something like that, or you'd be more sympathetic to us. I don't think that's accurate. On Chinese misunderstandings of the U.S., I think maybe the major misunderstanding, and perhaps someone who's more plugged into, the Chinese leadership than I am could correct me, but I get the feeling that they don't really believe that separation of powers is real, or that, the private sector really doesn't take orders from the government, and they're thinking that if you believe that, you're probably a sucker. Come on, we know the president can really call up the chief justices of the Supreme Court and tell them what to do, right? Come on. Be honest, right? And, because they can do that in their system. And I think they just assume that, every system works basically the way their system does. And so they think that separation of powers is just a mask designed to trick naive, gullible, foolish people. Whereas, as we know, it's actually real. Similarly, I think they maybe don't understand that senior politicians can't call up some company and tell them to jump, and the company CEO will then jump.
Right.
A big company in the U.S. I mean, the example I like to use in terms of access to data is Apple. When there was the iPhone of a terrorist suspect who was killed, and then they recovered his iPhone and they wanted Apple to break it. And Apple said, no, thanks, we'd rather not,
Right.
They had to take them to court. I think before the case was ever decided, as I recall, somehow the government managed to break it on their own. So I don't think we ever had a final decision. But it's certainly absolutely true that Apple, were perfectly capable of saying, no, thank you, we'd rather not, or see you in court, right? Which is completely, unthinkable in China, right? That the Ministry of State Security can walk into, Huawei's offices or Alibaba's offices or, ByteDance office and say, give us your data. And then the company says, see you in court, right? Never happened. Never happened. They both say, yes, sir. And so I think maybe Chinese leaders don't truly believe that separation of powers exists, or I should say, don't believe that separation of powers truly exists.
Well, thank you very much for being here with me today and for discussing the Chinese legal system and your research with China. It's been a pleasure talking to you today, Professor Donald Clarke.
Thank you. My pleasure to chat with you.